We now continue with regards to jurisdiction over the person of the accused. Okay? As ito yon, nakalagay sa screen, naka-flash po. Okay? It was held in the case of Valdepeñas versus People. Okay? And case of Jimenez versus Nazareno. It was held that jurisdiction over the person of the accused is acquired upon his arrest or apprehension with or without a warrant, or his voluntary appearance, or his submission to the jurisdiction of the court. As a general rule, it is settled by the court, okay, that seeking affirmative relief is deemed to be a submission to the jurisdiction of the court. The voluntary submission, ang pagboluntaryong pagpunta ng akusado, okay, to the jurisdiction of the court may be effected by filing. Okay, pag nag-file siya ng motion to quash, okay, appear sa arraignment, or participating in the trial. Okay? So, by submitting oneself to the jurisdiction of the court, okay, as where the accused actively participated in the trial, tas nag-present din siya ng mga ebidensya, okay, the accused has deemed to waive his constitutional protection against illegal arrest. Okay? Tayo dito sa number 4. When injunction may be issued to restrain criminal prosecution. As a general rule, okay, the court, ang isang korte po, hindi po yan mag-i-issue ng writs of prohibition or injunction, preliminary or final, para i-enjoin or i-restrain ang criminal prosecution. As a general rule yon. Hindi po mag-i-issue ang korte kung writs of prohibition or injunction para ipahinto ang criminal prosecution. Hindi, general rule, hindi gagawin niya ng korte. Okay? Pero may mga extreme cases, may mga napaka-importanting sitwasyon na ang korte, okay, may mga na-provide siyang exemptions. Okay? Ano yung mga yon? Okay? These are the enumerations. Example lang, di ko na babasahin lahat. To afford adequate protection to the constitutional rights of the accused, for the orderly administration of justice, to avoid oppression of multiplicity of suits, where there is a prejudicial question which is sub judice, where act of the officers are without or in excess authority. Yan, mga yan. Pag ito yung mga present, kita nyo to, napakarami, 13. Okay? Itong 30 na yan, present yan, pwedeng mag-file, okay? Pwedeng mag-issue ang korte natin ng writs of prohibition to enjoin or restrain criminal prosecution. Okay? Of course, I already discussed to you the different, okay? Yung mga jurisdiction ng court kanina. Okay? I'll just check. Okay? Remember in your remember that in your Sandigan Bayan, okay? Sandigan Bayan. Okay? The criminal jurisdiction of the Sandigan Bayan as provided in your PD 1606, RA 7975, and RA 8249. Okay? The jurisdiction of the Sandigan Bayan, okay, or the so-called is provided by those laws. Okay? Ang sabi dito, ano ang criminal jurisprudence? Jurisdiction nila, sorry. Okay? The Sandigan Bayan shall exercise exclusive original jurisdiction in all cases involving violation of RA 3019 or the so-called Anti-Graft and Corrupt Practices Act. Okay? And of course, your Article 1379, okay, the Revised Penal Code, okay, where one or more of the accused are officially occupying the following positions in the government, whether in permanent, acting, or interim capacity at the time of the commission of the offense. Okay? Example lang, hindi ko na enumerate lahat kasi marami ito. Okay? Officials of the executive branch occupying the position of regional director and higher. At ang salary grade nila is SG27 and above. Okay? Example lang, di ko na ma-enumerate lahat. Sila governor, vice governor, mga sangguniang panlalawigan, mayor, vice mayor, mga sangguniang panlungsod. Okay, you read your Republic Act 3019 because it enumerates who are those that are within the jurisdiction, criminal jurisdiction of Sandigan Bayan. Ano po ba yung mga offenses subject to the jurisdiction of Sandigan Bayan? Okay? Number 1, those violations of RA 3019. Ito yung sinasabi ko sa inyong Anti-Graft and Corrupt Practices Act. Number 2, yung violations ng Republic Act 1379, also known as yung Act declaring forfeiture in favor of the state property found to have been unlawfully acquired by any public officer or employee. This is later on amended. Okay? And of course, those violations provided in your Revised Penal Code, particularly your Book 2, Title 7, Chapter 2, Section 2. Okay? Provided dun sa Articles 210 to 212. Ito yung yung corrupt practices ng isang public officers. Yung mga bribery, in any form. Kasi meron direct and indirect. Okay? Next one. And of course, those other offenses or felonies, simple man yan or complex. Okay? Which of course involves the public officers. Mga student regent. Okay? Ewan ko kung merong student regent sa inyo. Yung mga student regent ng isang state university, they are considered to be public officer. Okay? This is settled in the case of Serrana versus Sandigan Bayan. Okay? In this case, yung petitioner po, in one case contended that the Sandigan Bayan has no jurisdiction over her person. As a student regent, ang sabi ni petitioner, she claimed that she was not a public officer since she is merely a representative of students. Okay? Contrary to other regents who held their position in an ex officio capacity. She added that she was just a simple student at wala naman siyang nare-receive na salary as a student regent and thus could not fall under the salary grade, di ba? SG27 nga. Okay? The argument, sabi ng Supreme Court, the argument that she was not a public officer was struck down by the court. Sabi ng court, you are wrong, Miss Petitioner. The petitioner, sabi ng Supreme Court, is a public officer. A student regent of a state university is a public officer whose position is covered by the law, vesting jurisdiction over the Sandigan Bayan. Okay? The Board of Regents of the University, okay, performs functions similar to those Board of Trustees of a non-stock corporation. By express mandate of the law, yung petitioner po natin declare the court as a public officer contemplated by PD 1606. Okay? Yung compensation, is it an element which is essential? The answer there, by sabi ng korte, the compensation is not essential. Okay? So, next one, we go with the prosecution of offenses. Okay. What is the purpose of criminal action? Okay. The purpose of criminal action in its purest sense is to determine the penal liability of the accused for having outraged the state with his crime, and if he can be found guilty, to punish him for it. Okay? So, in this sense, yung mga party sa isang action, example, yung people of the Philippines, diba? Pansin nyo sa mga, pag nakikinig kayo ng mga kaso, diba? People of the Philippines versus Pedro Cruz. Okay? Criminal case number 1, 2, 3, 4, 5, 6 for the crime of murder. Okay? Here, in this sense, ang party sa isang action is yung people of the Philippines because it's a public offense, sa public crime. It affects public interest. Yung pinatay ni Pedro, that is your private complainant. Okay? So, of course, may private interest. Okay? In that sense, si accused then, he is also a party. So, yung offended party, he is the private complainant. He will now become the witness of the people of the Philippines or for the state. Okay? Question: how criminal actions are instituted? Okay? The institution of criminal action generally depends whether or not yung offense po nagre-require ng preliminary investigation. Okay? Paano daw mag-file ng isang criminal action? Sabi ng batas, depende muna yan. Depende muna. Tignan natin kung required bang preliminary investigation. PI ang tawag nila dyan. Di ba yung ibang tao, minsan ang PI natin, bastos. Pero sa batas, ang PI natin ay mabuti. Preliminary investigation. PI. So, what offenses require preliminary investigation? Ito nakalagay. Those where the penalty prescribed by law is at least 4 years, 2 months, and 1 day. 4, 2, 1. Okay? Please do not forget that one. The rule 4, 2, 1. Okay. Question: what is the effect of the institution of a criminal action on prescription period? Okay? Anya kano ti epekto na ti pag-file ti may nga kaso? Di ba alam nyo ba na ang mga crimes ay may expiration din. Yung tinatawag nating prescription period. Okay? Here, the institution of criminal action shall interrupt. Okay? Ibig sabihin, mag-i-stop yung running of prescription period of the offense charge unless otherwise provided by special laws. So, it will be interrupted. Please do not forget this word. Ano ba yan? Yan, interrupt. Okay? Question. Kinasuhan ni Maria si Pedro ng rape. Ngayon, umatras ngayon si Maria. Nahihiya ako, ayoko na. Ganyan, dami ko ng gastos. Does the Does the desistance of Maria, the offended party, bar prosecution? Hindi na ba magtutuloy yung kaso? The answer there is no in the case of people versus Amaka. Okay? Here, sabi ng korte, it will not bar prosecution. Tuloy ang kaso, sabi ng korte. Desistance does not bar the people of the Philippines from prosecuting the criminal action, but it operates as a waiver of the right to pursue civil indemnity. Okay? So, ibig sabihin niyan, tuloy ang criminal action, pero hindi ka na pwede mag-claim ng civil indemnity. Okay?